All attendees are in listen-only mode.
All right, and I think we are live everywhere. So just real quick, a recap I started to say. For those that are registered for the webinar through webinar or GoToMeeting.com, you're on my computer watching the PowerPoint. I have simultaneously, I'm on Facebook doing it like a podcast for my friends and family. I see some people signing on. Good to see you. Thanks for the support. I'm also posting simultaneously to Twitter, which I don't think I've ever done before with my webinar. So that's kind of a new thing for me. And we're here today on May 30th, 2019, in New Jersey. This is always applicable to New Jersey law. So if you're watching at any other time that the laws may have changed, if you're watching in any other state, the laws may not be the same. So the webinar is 8 tips for men who want custody in New Jersey. I'm going to take a minute and just explain to you, at least those watching through the registration, the GoToWebinar, the nature of this presentation. It's intended to be an hour. I schedule it for an hour. I try to do my best to stay within that time frame. I never really know how long something's going to take because it depends how much I care to say about the topic, and then how long it takes to get through each different segment. It's a one-way communication on all these forums, but each of them, although Twitter may not, at least may not have an option for me doing a live to answer questions, but Facebook has the ability, you can post comments as we go if you want me to address them. And for those watching in the GoToWebinar, you should have a chat panel or a control panel, let's say, on usually the right side of your computer. In that, it will have a pull-down menu for questions. I'd ask that you type your questions as we go, but I won't be addressing them until we get to the end. I just find it usually not only breaks up the flow of the presentation, but sometimes your questions change, or you may have other questions based on the information. Your questions may even be answered by the time we get to it and new information. So it's just better to leave them to the end, but write them as we go so that you don't forget it. I've also attached to the webinar the PowerPoint I'm going to be using tonight, in case you wanted to download that. Often my PowerPoints will have a lot of case law and statutes that are often helpful. This one doesn't really have a lot. It will have some custody factors that might be helpful for you, but I'm planning to go through those at length. But for those who are watching, if you want to download it, it's available to you. This will also be posted later, usually in a couple weeks, on my website, micklinlawgroup.com, as well as my YouTube page. I'm not posting on YouTube now because they get pissy when you put duplicate content up, so it's better just to have the recorded presentation. That being said, let's get into a little bit of the information here and give some background and start off. First of all, those watching on the webinar, if you have not worked with me, this is me. My name is Brad Micklin. I'm the managing member and lead attorney of the Micklin Law Group. I am licensed in New Jersey, state and federal courts. I founded the Micklin Law Group in 2001 as a general practice attorney. And over the time and up until recently, I've concentrated my practice in men's and fathers' rights in divorce, custody, and family law issues. The next slide is some of the awards I've been honored to receive. Fortunately, I'm proud to say it's not all of them, but it's some of them. The rest are on my website. I put these up not to impress people or to show off, but just to show those that are unfamiliar with me, that haven't worked with me, that you can trust in my experience, my dedication to the work that I do. And I think some of these awards hopefully speak to that. I see some new people signing on Facebook. Great to see you guys here. I love the support. Hope the information helps you or somebody that you know. Moving along in the webinar. So let's just jump right into it. We got 8 reasons. The first one is, I know everybody on the social media that doesn't see the handouts is sitting on the edge of their chair to see what number 1 is. Number 1 is not going to be surprising to most people. I see some family members signing on. Those that can't see the webinar, number 1 is retain an attorney who specializes in family law. And I'm not saying that because I am an attorney who specializes in family laws. I'm not saying, I'm repeating and not saying it because I am one. And I guess I got to say concentrates because I don't think we're allowed to say specialize. But it is probably the most important thing when you have a high conflict type of case. And if you're watching this for custody issues, it's likely you anticipate that you're going to have one. You want to avoid what I call a general practice attorney, at least if you can find somebody who concentrates solely in family law. I have a lot of reasons for that. I'm not a huge fan of the general practice attorney, but they fill a good need in many cases, but not in a custody case. I personally don't think it's possible for any one person to stay abreast of all the developing issues in any area of law. And when you're a general practice attorney, you just have to. So I think also one of the things you obtain by having somebody in a family law concentration is that they have a better ability to see the issues. They have better forms and paperwork because it's more the practice focus, and it ends up being in some ways faster and less expensive than it might be for an attorney who's not as well versed in the area of family law and custody issues. Second, along those lines, don't sign anything before you hire an attorney who concentrates in family law. I get clients all the time come to me with this horrible agreement that they signed because they had no idea what they were doing or what their rights were, and they didn't get even a consultation. And in New Jersey, if you sign an agreement, it's binding. There's challenges to trying to undo or reverse that. There are some ways sometimes, but generally speaking, it's not going to happen. So don't sign anything without bringing it to an attorney and an attorney who's well versed in family law. Now, one of the problems you're going to run into that is many, if not most, good family law attorneys won't really be able to tell you at the first review of an agreement if it's a good agreement or not, because we're usually going to need more information to be able to advise you. But it's a good start. At least they'll be able to tell you some ground rules. They'll give you some, hopefully, frames of references to what your areas are and what the likely outcomes will be, at least to narrow the focus when you move forward. All right, number 2, for those not watching on the webinar, number 2 is keep child support out of custody and parenting time negotiations. There's many reasons for that, which I'll go through. First is the law in New Jersey says that they are separate. Whether you're paying support has nothing to do with whether or not you get parenting time. A lot of people think that they're going to get a big reduction if they have a lot of overnights, which isn't the case. A lot of people will also believe that if they're not getting parenting time because the other parent is complicating it, that they shouldn't pay support. That also is not the case. Simply put, New Jersey will do anything it can to make sure that you pay child support, whether or not you get to see your child, whether or not they're even helping you see your child, because they want to make sure that they don't have to, the state doesn't have to support the children. But going to specific reasons why it doesn't help you or serve you in a case to do that, first is it's going to appear like you're disingenuous when you're asking for custody. As an attorney who concentrates in men's and fathers' rights, I'll be first to admit I have a lot of clients who come in and they want to find and fight for custody. And I can tell it's simply because they just don't want the other parent to have custody. It's a button that they push. So when you come in and you say, I want equal parenting time or 50-50 custody, and I don't want to pay support, people wonder what the motive is behind that. Second, you need to make sure that your work and life schedule can accommodate the parenting time that you're asking for. Again, I'll get clients often who will come in and say they want equal physical parenting time, but they work in the city as like a financial broker of some sort. So they leave the house at 6 and they get home at 8. Whereas the other parent may be a school teacher who has a similar, if not identical, schedule to the children and can better accommodate their needs. That's just not a good match. And if you come in asking for a parenting schedule that doesn't fit your work schedule, again, you're going to look disingenuous. Lastly, on the issue of not involving support and parenting time, you want to have an idea, like a game plan, when you meet with your attorney of how you're going to accommodate the schedule that you want, what changes you can and will be making in your life and work schedule, what flexibility you have with regard to that, and how you see it changing in the future. That's probably going to be the most important, and we'll talk about that a little later into the webinar. But custody and parenting time often changes as children grow older, and you want to know as early as you can when you're going to want to revisit or revise your agreement so that you can match these changing needs of your children. And last, and it goes a little bit back to what I said in the beginning about being disingenuous, don't fight for custody just to fight for custody. Again, a lot of people will say, I'll fight, I'll take custody from you as a pressure point. It's not good for you. It's not good for your litigation. Certainly not good for your children. So the lesson to be taken from number 2 is be ingenuous about your plan. Have one. Communicate to your attorney what it's going to be, and make sure that you make the proper changes in your life and schedule to accommodate that. Moving on to tip number 3. Keep a journal or calendar of parenting time events. This can be challenging, but it's crucial. I put up a list of things that you want to calendar. For instance, I'll read them out for the people that don't have the benefit of the PowerPoint. Quick hello to people on Facebook. I'm glad to see everybody signing on. Love the support. Appreciate it. Hope it helps you or somebody that you know. Getting back, so you want to record things like your important conversations with the other parent, important dates both in the past and future, activities, things that occurred at the activities, who did the pickup and drop-offs, whether you were there, doctor's appointments, what they said, their names, things like that. Homework assignments, any special problems or interests that the children have, their teachers' names, and any deviation from your parenting schedule if there is one in place. And this is probably one of the more important ones. The calendar you want to use, and you can use a ton of different calendars. I usually recommend something simple like a Google Calendar, because you can usually you can save and print pretty well from there. Family Wizard's also another software that the court promotes, and I usually recommend a lot. There's a little bit of a cost to it, but it helps you communicate and document things. But you want to be able to record everything, and specifically problems that you're having, probably even more important, problems that you're having, as well as things that you're doing, because often you're going to go into court and there's going to be a large discrepancy between who claims to have the bigger or greater share of the parenting responsibilities. And you want to be able to show that, because the laws haven't changed as much as men want to believe in New Jersey. They've come a long way and they're progressing, but they haven't changed entirely. And even worse than that, a lot of the attitudes haven't changed, even as the laws have changed. So you really need to be able to show that you are not your stereotypical fun dad, as I call them. You know, that somebody should just get every other weekend because he works a lot during the week. It's not the way that we live now, and it's not the way the parenting time should be. And the progression of laws support that, but we're just not entirely there just yet. Number 4 is negotiate important provisions into your divorce agreement. This could really be any kind of agreement. Specifically, it's important in a divorce agreement, but if you have a consent order that you're reaching between the other parent, or you're writing something down on a napkin in a diner because you want to have some kind of agreement, any kind of agreement should have the points I'm going to mention in a moment, because sort of what I referred to before, that you need to be able to contemplate and plan for what's going to happen in the future. And if you can foresee that and include that, you'll be the better person and you'll have much greater custody and parenting rights. So first is the problem that you run into with negotiating your settlement agreement is not responding to your attorney, who again should be a family law attorney. You want to address relocation outside of New Jersey or even inside of New Jersey. There's a new case that speaks to the law regarding moving out of New Jersey. And there's some, in my opinion, confusion about the significance of the decision. Some think it's more significant than others. it's very not easy. It's permitted to move inside of the state without any permission. So you want to build in restrictions if that serves you to the other parent's ability to move out of state and how your custody rights will change if that person does try to do so. You always want to have, if this works in your life, what's called a right of first refusal. And I hate to sound cold because I think that's a real estate phrase that we use, but the right of first refusal says that if one parent is not going to be able to exercise his or her time with the children, the other parent should be given that time or at least offered that time. I generally recommend parents seek that, but you have to remember it kind of cuts both ways. So you may not want to necessarily lose your parenting time just because you need to use a babysitter. So you need to be able to word that carefully. I usually recommend you consider something like an extended period of time, like not 3 hours where you might just be running to the mall, but maybe an 8-hour period or an overnight. If they're not going to be with the child, then the other parent should have that right. You want to have a schedule that has FaceTime and telephone time to communicate with the children when you do not have them. This isn't as significant when your children get older, 5, 6, and up, because they usually have not a great deal they want to talk to you about. But I usually recommend you have a schedule just to keep in touch with them over the period of time where you're absent. So it doesn't have to be every single day if you don't have parenting time, but it should be every couple of days, even if it's just to kind of touch base so that your kids know that you're still around and involved. Vacation time is important. Most of the time we talk about parenting time like every other case, meaning you get 2 weeks in the summer and you get, half of the school breaks. But you may need specific vacation time. You may need to travel out of the state or the country, and you might want to build that in. These are things that are going to be important that you don't want to have to negotiate and fight for in the future. You should have a requirement that there has to be a consultation with the other parent before there is any kind of vacation or travel. And you definitely want to build in times where you think you're going to want to revise or review parenting time, as I mentioned earlier. This is probably the most significant issue. Changing parenting time is much more complicated than people think. People just assume that if many years pass, it's time to revise our parenting time, or the children are now in school or a different school and we have to review parenting time. That's not really the case. It would seem like it should be because that would make common sense, but common sense doesn't follow the law in New Jersey. The law in New Jersey says it needs to be a material and substantial change of circumstance before you can revise your parenting time. That's, first of all, not really even defined clearly by state case law. There's some examples of it, but nobody really knows what that means. And to have to prove that whatever triggered the reason that you want to review was material and substantial is challenging. And it takes several months to do that, if not longer, between the motion and litigation process in New Jersey and the hearing that you may have that has to follow it. So build it in. If you think you're going to want to review it when they change schools or at a certain age or due to religious events, build it in now so that there's no question when that time comes. Another point also, not in the PowerPoint, but along with vacation time, school breaks, there's the ability to negotiate that child support will be suspended during that time. It normally is not, because the costs that child support is intended to cover, most of them continue for the other parent even though they don't have the child. But you can agree that child support will be suspended during vacation times, any kind of long holiday break, or any long parenting time that you have. It actually could be suspended for any parenting time that you have if you agree to it. But extended makes sense if it's a couple weeks. Some people do a full month in the summer. But it won't if you don't build it into your agreement. We are moving on to number 5. See some other clients popping on. Sorry, I always jump by to say hello to people I can see signing on. Actually, I'm going to check to see who signed on here. Oh, So I think the people that are watching the webinar don't see the other people who signed on. And obviously, social media never sees anybody. And I never want to disclose anybody, even if it's a client, because it's just confidentiality to me. But I do see a client who signed on. Glad to see you. Glad you're getting some free advice from me. I bet you are too. I'm not sure who signed on late, but the chat panel that you have, or the control panel, has an area for questions. I mentioned in the beginning to put any questions you have there while we go through this, and I'll take whatever time is necessary at the end. All right, so number 5 is understand that the tender years doctrine has largely eroded. The tender years doctrine, and I've never been a fan of this law. The tender years doctrine says that a child of tender years, and usually it's 0 to 3, or even a little bit more, is their best interest is served by being with his or her mother. Now, that's archaic and inaccurate in many cases. Now, I don't want to get a lot of hate mails and angry tweets. Some cases it's appropriate, and like I said, and when I open this up, times haven't changed so much. We do still see more mothers as the primary caregiver in an intact family, but nonetheless, 10 years doctrine is outdated, but it has not necessarily been replaced. What we now have is a statute that says there's a presumption in favor of as much time as possible for both parents. As close to 50-50 or equal as possible. It doesn't actually say yet that it should be 50-50 or that there's a presumption of equal time. I think the legislature tried to pass that. It didn't pass. I think it's coming and we'll get it soon. But at this point, the statute says as much time as possible. That's not necessarily a bad thing. That can be something that you use as a way to say maybe you should even have more than 50%. Just like mothers had historically, traditionally, they had all week and dad had alternating parenting time on the weekends, alternating weekends. Why shouldn't a mother possibly have an alternating weekend schedule? Let her be fun mom, and you can have a child during the week. Lastly, on the 10 years doctrine, for those that are looking at the PowerPoint, because I covered most of the points already there, parent of primary residence is often a big issue. And a lot of times it's an issue with people simply just because they think it's important. And it can be in certain circumstances, but you don't always have to have one. And I usually recommend that my clients that are fathers don't assign that to the other parent. We'll get into a little bit of what that means, but generally speaking, it's going to be most significant for school registration and relocation. And if you give the other party that designation, then you may lose some control over those issues in the future. We'll talk a little bit about that when we get to the different types of custody that you should know if you're going to be in a custody dispute in New Jersey. Moving on to number 6, best interest standard and statutory custody factors. Now, this is what the court is supposed to be looking at whenever there's a custody dispute. They're also supposed to be looking at it in many child support circumstances, but they don't. Truthfully, I don't think they really even look at it in a custody because most people ignore it and just try to come to an agreement. But if you're going to go to court, you have to use these factors. If you don't use the factors and you're in a custody trial, the court will call that to your attention at the end and possibly give you an adverse ruling because you failed to address them. So I'm going to go through each one, even though there's several. I think there's like 14. I'm going to go through them. I'm going to read them so that the people that don't have the PowerPoint can hear them and write them down. People that have the PowerPoint or that are watching the webinar, maybe you want to tune out for the next 5 minutes because it might just be a little monotonous to you, but I think it's important to cover it. So the first one is the parties. Gotta get up. Okay. The parties' ability to agree, communicate, and cooperate regarding matters relating to the child. I'm not going to bother explaining. I think that's clear. One caveat to this, however, is many times you're in a custody trial because you can't communicate with the other parent. And a lot of people want to bring that point out to the court. And sometimes I caution them against that because if you're going to tell the judge that you can't communicate, that judge may rule adversely to your custody rights, even if it's not your fault and you're not the problem in the communication. The concern is for the child. So if the parents can't communicate, the court has to make a decision that will eliminate that problem. So tread lightly on communication problems. Willingness to accept custody and any history of unwillingness to allow parenting time. This generally means if you've been denied parenting time by the other parent. Willingness to accept custody, if you're in a custody trial, that should be a given. But more often, I think the statute provision here is speaking to when you've been denied access to your child, alienation issues, things like that. Interaction and relationship of the child with its parents and siblings. This is growing even more significant now because we see a lot of blended families that didn't exist before. Step siblings, grandparent rights, countless other situations I won't go into because there's just too many of them. But we're seeing a lot of new families rise, and because of that, we're seeing new sibling relationships. So this is very important. It's an issue that's more important than it used to be many years ago. History of domestic violence. It's important to remember here that domestic violence does not need to be a restraining order. It doesn't need to be a criminal matter. It doesn't have to have been reported. If it was an act of domestic violence that occurred in the home and the street, it's an act of domestic violence. You should be bringing the information to the court whether or not there's a paper trail or a legal proceeding that documents it. Safety of the children from either parent by physical abuse or by abuse between the two parents. This always is going to be significant. Depending on the gravity and level of it, you may have DCP&P, formerly known as DIFUS, involved. But this, again, is similar to the history of domestic violence. It's sort of like the domestic violence on a child is going to greatly impact the custody decision a court will have, both for custody and for parenting time. Moving along, the preference of the child when of sufficient age and capacity to form an intelligent decision. Some people believe a child never reaches that age when it comes to custody matters because, first of all, it's a complex issue to ask any child what parent they want to live with, but it's also a very bad position to put a child into, to have to pick between parents, to be in the middle of a dispute of parents. Sometimes they're trying to please one or the other. It's a lot of issues to involving a child. So in a lot of cases, there is no sufficient age. But generally speaking, if there's going to be one, it's usually around 13. The courts will start to interview children. Usually it's what's called in camera, which means behind closed doors. It's recorded, but nobody's watching it. Now, if they do interview the child, it doesn't mean that they're going to accept the child's view or opinion. It just means that they're taking that into consideration. Needs of the child. This could be educational, medical, health, any special needs, any special talents that the child has. Often another place where I think people overlook bringing important information to a court, but also contemplate not only their current needs, but future needs. Again, if they have an inclination to be a good athlete, or they have certain educational skills, maybe they have a hobby that they're passionate about, anything that you can see developing in the future, you might want to address as early as you can in a custody proceeding. Stability of the home environment offered. This is hard to challenge, but there are some circumstances when it becomes an issue, obviously. More often than not, when it's a comparison, if you have many children and one parent lives in a very small, let's say a studio apartment, or has other children from a prior marriage or a blended family, or their parents living, whatever the reason could be, stability may not be the best word for what the courts look to, but you want to look to every factor about the housing, not just how stable it is, but how comfortable it is, what amenities would be provided for the children or child that would be living there. The quality and continuity of child's education. That means obviously if the child's going to be either switching schools depending on the custody that you're seeking, or if you are going to be keeping the child in the same school because your proximity is close to one another, you want to make sure that that is mentioned to the courts also. Fitness of the parents. This is a hard issue really to challenge. More often than not, well, first of all, parents are presumed to be fit in New Jersey until or unless shown otherwise. And a lot of people want to go in and challenge the fitness of the other parent, usually because they're angry. you can't usually do that successfully and credibly because you chose to have a parent, or you chose to have a child with this parent, and to later argue that the parent's not capable raises questions about your own judgment if that's truly the case. And it's usually viewed as being just a tactical attack on the other parent, and it's going to work against you in a custody issue. So I usually stay away from that unless there's a genuine issue of fitness. Moving on, continuing, proximity to the parents' homes. I think we already talked about that before. The extent and quality of time spent with the child prior to the separation and also after. And that goes back to what I was saying earlier about using the calendars. You want to be able to document everything that you were involved in, not just pick up and drop offs, but the activities, the doctor's names, their friends' names, their teachers' names, medical problems they had. You want to be able to show that not just you spent a lot of time, but it was quality time and that you're fully familiar with all the issues involving your children. I'm going to give another quick hello. I see a lot of people still signing on, which is great. I love that. And I see some attorneys, local attorneys checking in on me. Tell me if I'm doing a good job or not. Tell me if I'm missing something. Actually, maybe even don't want to because it probably benefits you guys, but help me out here. I see an old client signing in. It's great to see him too. All right, so I'll get back because people in the webinar could care less about the people on my Facebook pages. Parents' employment responsibilities. Again, I touched on this earlier, and it may show you how a lot of these issues get kind of intertwined and why you need to be really practical when you prepare these. But your employment schedule is not just for parenting time, but also financial responsibilities, the ability to be there for the child for homework and extracurricular activities, and also to co-parent. Your availability to be a backup and support for the other parent is going to be significant. Age and number of children, obviously, depending on how many you have and what their ages are and their needs, wrapped together as being something the court needs to consider and something you definitely want to present and address when you hit these custody points in any kind of a trial. All right, we're coming slowly towards the end. We're on number 7, and this truly is an 8-tip seminar. Understanding the different types of custody. And this is a little ironic if you ever met with me in a consult or as a client, because I more often than not tell clients don't use custody terms because you get them wrong. And you'll go in and like people will say, I want sole custody. And they really don't mean that. They mean they just want like they want primary custody or physical custody. So when you go in, if you use the wrong term, courts may think you're asking for a different thing than you really are. And in some cases, like when you come in and ask for sole custody with no basis, you'll look unreasonable. And you're not intending to. You're just using the wrong term. So I generally say not to use them, but many of the webinars I do, I go through them anyway in case you want to try to. And it also helps you at least understand when other people are using them. So first is legal versus physical. So this is between decision making and overnight. So legal is decisions, physical is overnight. Major decisions, when it comes to legal decisions, that's what we're speaking of: religion, medical treatment, education. Religion is kind of tough because courts are usually very constrained in making religious decisions, but push comes to shove, if parents can't, they will. So it's questionable whether or not that would be considered something in the legal decision. Day-to-day decisions like homework and bedtime, even often where they go to daycare, is legal as opposed to physical. Extracurricular activities, legal. Physical is really just the amount of overnights. Now, with regard to legal and physical, you can then have sole or shared. And this is sometimes where people start to split hairs and get a little bit confused, because sole decision, if it's legal, if you have sole legal, that means you can make all the decisions, even though you should still notify and involve the other parent. But sole doesn't necessarily mean zero overnights when you're talking about physical. So you could have, for instance, you could have sole legal custody where you're making all the decisions, and shared physical custody where the parent still has overnights. You can also note that shared physical doesn't mean equal parenting time. If you have one day a year, you have shared physical custody. And you don't even need to have necessarily an overnight for it to be an overnight. It's at least for child support purposes, when you're talking about the credits, it is a 12-hour period of time, which would count as an overnight. So if you're picking up early in the morning and bringing them back in the evening, that still may be an issue for credit in child support. Also, when you talk about like vacation times and school holidays, it's important to calculate those times into it also. Just doing a quick check on the time. Looks like we're still pretty good, actually, pretty moving early. Some issues about these types of custody. I think we're on 8, even though I may have skipped past the PowerPoint page for it. Maybe there just isn't a PowerPoint page that says number 8. But number 8 is watch your language and behavior in all aspects. First, I tell everybody, and I'll hit this in a second in different ways. Well, let me go through the PowerPoint first, and I'll give you my thoughts about it. First, you want to do everything you can to co-parent. It's better for your children. The courts, I was going to say the courts prefer that. The courts look for that. The absence of that will actually hinder your ability to have custody rights or generous custody in the future. You don't want to speak negatively about the other parent. First, again, bad for your case, horrible for the children. I always say children want to believe their parents are superheroes. So when you tell the child something bad about the other parent, it actually hurts the child. And I don't know why any parent would want to do that intentionally. Avoid inappropriate conduct that you don't want to have to explain to a judge. Now, in my PowerPoint, I mentioned things like excessive alcohol, drug use, corporal punishment, domestic violence. That's all, common sense. But also, you want to avoid any badgering comments or any conduct, any aggressive attempts to pressure a settlement, for instance. All these things will negatively impact your custody case. Keep your composure and avoid outbursts, both in court and out of court. I always explain, and it's on my PowerPoint here, that in New Jersey, you can record a conversation that you're a party to without the other party knowing or the other person knowing. So I always tell people, assume you're being recorded at all times, not only because we can record our conversations, but because there's so many recording devices around between security cameras and GPS devices and cell phones and phone apps that it's safe to assume you're always being recorded. Speak and write emails and texts as if a judge will see and hear them. This also goes for voicemail messages because they may often see them. And the problem, and I see it more often with text messages. The problem with email and text messages is you can respond so quickly in a conversational manner that you will respond as if you're having a conversation. So the stupid things that you would scream like, I could just kill you, people are now putting in their text. I had one client who unfortunately had a restraining order issued against him because he sent 21 text messages saying, I hate you, like just back, I hate you, I hate you, I hate you. And the judge found that to be harassing, an inconvenient hour, and exposed her to danger, and a restraining order issued against him. And it's solely because he was able to unleash his frustration into a text message that was read later. And again, voicemails. Don't leave angry voicemails. They can be used against you in court. With regard to recording conversations, the last point that's on my PowerPoint is I do advocate for my clients to record conversations with their other spouse or the other parent without letting them know, not just because it will often help you in a custody dispute, but there's often a lot of false allegations of domestic violence, and it's a great weapon, not just for a trial, but when the police come out and there's an allegation that there was a harassing communication or a physical threat or harm, and you have a recording from that moment that shows that nothing but normal conversation was occurring, it will keep you out of a lot of trouble. And a lot of people aren't crazy about that advice. I know a lot of judges don't like when I give that advice, but I do it anyway because it's just best for the clients. That is point 8. So I'm going to move in quickly, see if there's any questions on my chat panel. I'm not sure. Oh, quick hello to see some new people sign on. This is actually like the best turnout I think I've ever had for this. I must either have a lot of friends or there's a lot of custody problems in the people that I am friends with. So I'm going to reach out to the people on Facebook. If you have any questions, I guess you could just like type it while you're on the screen. I don't know who sees whom. I think it's only if you're friends with friends. But you can also message me or you can call me tomorrow with a question. So looking at my chat panel, there is at least one question here. I just got to open it. All right, let me just expand. Just give me 1 second. I just can't expand this box here to read what the questions are. I'll get it. Just give me a second. All right. I think we're coming to it. Have to manually expand the chat panel. All right, so let me see if I can. All right, I'm going to do my best to read these questions because for some reason it's not expanding my my control panel. So I'm going to read it and I'll do my best to answer whatever I think it's asking. So the first says the PL spousal support. I guess that means the temporary penalty has devastated me and rendered me homeless. I'm sorry to hear that. How can I possibly negotiate a fair parenting plan under these circumstances? Well, yeah, you won't, quite honestly. I don't know if the question is laced with a little hyperbole or if you're actually on the street, but that's unlikely since you're watching my webinar through a computer. So I'm going to assume that you have a costly support, which is making parenting time challenging for you. It's hard to know without knowing anything about how or why that order was entered. But if it truly is crippling you financially, there's a good chance it was entered incorrectly. Now, again, the standard to change something like that is usually a substantial material change of circumstances. But in some cases, the court's not that rigid about holding you to that guideline, especially if you're not in a divorce, meaning if you're in a custody or parenting case. The channels to review support are sometimes handled a little less formally. So you might be able to. Additionally, a change in the parenting schedule, if you were successful, might be a change of circumstance to allow you to change the support that you ordered to pay, especially if there's a child support component in that. So I hope that helps. If it doesn't, put another question up so that I can then address that for you. Okay, so the next question here is, what do you do if you're dealing with a narcissist? Depends on the degree of narcissism. That is an area actually that I'm pretty well versed in. First, go to my YouTube page, which is Brad Michael Micklin, Micklin. I have a ton of information. I've done a ton of webinars. I've done a lot of podcasts. I've done a lot of posts on divorcing a narcissist. I'm actually about to publish a book on it. And there's a lot of information there about divorcing a narcissist. And it's called Divorcing a Narcissist because that's usually the topic that's most significant. But it works. The tips really work to any kind of litigation. So if you have a parenting custody issue, those webinars will help. But most importantly, the tips for that I could at least get into here. One is to, like I said before, record everything. Expect the most egregious allegations could be used against you. Don't expect that they're going to be limited by the truth. They have an interesting way of viewing the history. So you need to be prepared with witnesses. You need to be prepared with experts. You need to be prepared with finances. So it's challenging. Any litigation with a narcissist is exceptionally challenging. I do strongly recommend you check the webinars I've done. Some are on my website, micklinlawgroup.com, but more of them are on my YouTube page. They should help you a lot. And if not, just contact me afterwards, and I'll do what I can to help you with that. I don't know if that's the last question. It's the last one I see, but I'm still having that chat panel problem. So I'm going to quickly check, see if anybody on Facebook posted any questions. I don't know if it works that way or not. So I'm going to assume it doesn't. But again, you guys know how to contact me. People on Twitter, I can't check that because it's tied to my cell phone. But you can always either send me a message, a direct message. You could also put a reply or question. Lastly, you can go to my YouTube page and post a comment once this is listed, and I can address it once you get to see it. So with that, I'm going to just give it another second to see if any other questions pop up. And I don't see any. I don't see any comments in the chat panel. So real quick, to those on the webinar, if I didn't get your question because I wasn't able to see it, type something in the chat panel. And although unfortunately everybody that's registered will see it, and possibly your name, I'm not actually sure how that works because I've never been on the other side of this. But if that's important, I make sure I cover the question you have. You can do that. I'm not seeing that. So I'm going to leave this up for a second. I'm going to sign off of my social media, Twitter and Facebook. Bye to my friends, family, loved ones, and everybody watching. I appreciate the support. Hope you're safe and dry because it's pouring where I am, and it looks like it's going to continue for some time. So be safe. I should be on tomorrow for my daily tip. I think earlier in the day. I think I scheduled it for 2:30. I'm not sure, but I'll post it in the morning what time I'm going to be on. Anybody has anything that they want me to cover, just send me a message. Let me know. With that, I'm going to wish everybody good night. Be safe, be cool and dry, and I will see you in some form hopefully soon. Good night. All right, to those on Twitter, I'm going to say good night. Also, I'm going to sign off there and wish everybody a good night. I don't know where you happen to be because it doesn't necessarily get limited to just New Jersey, but I hope you liked the webinar. If you did, certainly share it and check out my other ones on my YouTube page. With that, good night. And to those on my PowerPoint, I'm going to be signing off. Again, you can contact me. My email is brad@micklinlawgroup.com. That's MICKLIN lawgroup.com, all one word. And with that, thanks for coming. I hope this helps you. And let me know if I can help you in any way in the future. Go to my YouTube page, like I keep saying, has a ton of information for you. It's all free. And good night.